Okay, so welcome. My name is Benedict Schöpflin. I am the Executive Director of the Canadian Network for the Prevention of Elder Abuse, and I will be your host today. I am thrilled to welcome Krista, the National Director of the Canadian Centre for Elder Law, who is going to talk about CCEL's Practical Guide to Elder Abuse and Neglect Law in Canada. So before we begin, a few housekeeping tips and reminders for everyone. We're going to, oh, my bad, going too fast. Here we go. I was too far ahead. So, as I said, the webinar is being recorded, so please don't unmute yourselves during the presentation so the sound is clear for everyone. If you are on a computer, unmuting or muting yourself requires clicking on the little microphone icon. So it is green by default. If you click on it, it becomes gray. You are muted and everything is fine. If you're using a phone, you can mute yourselves by using the mute unmute button or by dialing *6 on your keypad. If you're, excuse me, if you're attending via computer, make sure that your sound is turned on, turned up, and that your headphones are plugged in if you're using headphones. You will see on my screen right here the phone number options if you need to at any point log off your computer and connect with a phone. And this is if you're experiencing any sound issues or a connection issue. The best way is to let us know so that we know what's happening and to close the window, hang up, start again. A few more things. We'll have a 15 minutes Q&A at the end of this presentation. You can type your questions ahead of time in the chat box in your little control panel, and we will address them all at the end of the presentation. And if you're not able to stay until the end, that's totally okay. We understand that we're all very busy. The webinar is recorded, and I'm going to be uploading the recording to cnpa.ca later this week, along with the slides. Before we go any further, I want to begin by acknowledging that the land on which I live and work is the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Your presenter today, I'm sure many of you are familiar with her, is Krista James. Krista is a lawyer. She is the National Director of the Canadian Centre for Elder Law, and her work addresses legal and policy issues linked to aging. She has a particular interest in how aging, gender, and other aspects of identity intersect. You can find her work on the CCEL website, which is on your screen right now, bcli.org/CCEL, and you can find her on Twitter at Krista Ellen. So without any further ado, I'm just going to unmute Krista and make her presenter so she can tell us everything about the practical guide. Where are you, Krista? Here you are. Okay, I'm going to make you presenter right away. Let us know when you are ready to go.
Can you hear my voice over the phone?
Absolutely.
Okay, that's the first step. You're requesting to unmute me, but you don't want to unmute me on a computer, right? Just the phone?
Just the phone. So you should be all right. And now I'm making you presenter. So remember to share your screen so we can see what you're talking about.
Doing that. Yeah, doing that right now.
Perfect. Okay, if you can make it full screen, that'll be wonderful.
Now, just a quick text question. It keeps asking me, saying that you've requested me to unmute me, but I don't want to do that because then I'm going to have both, right?
You're all good.
Okay,
Ignore
I'm just going to hide this window then. Okay.
Yes.
Keep blocking my screen. All right. Okay, I'm going to skip your housekeeping slides. Hello, everyone. I hope you can all hear me okay. Thank you so much for joining us today for this webinar. I just want to thank Benedict and the Canadian Network for the Prevention of Elder Abuse for hosting us, making this webinar happen. I want to thank our funding partner, which is the Department of Justice of Canada, And what I'm really excited about with this partnership with the Department of Justice is it's giving us an opportunity not just to update the guide, but to work with stakeholders across the country to make the best guide possible. The first issue was put out in 2011, and the funding context kind of rushed us, and that's not the best process. So I'm really keen to do something really working with folks. I've opted to phone in so you don't see my chatting face and show you the slides, just so that if there's any break in the internet during the presentation, my voice will be continuous, and you won't experience that break in the presentation, which has happened to me a few times recently. And just a warning that I do have a dog and a child in the background, and I'm hoping that things will be quiet, but life is happening in the background during the pandemic. So there's two things I'd like to do today with the presentation. Okay, somebody has a lot of noise in the background right now. Okay, so there's two things I'd like to do with two things I'd like to do today. I'd like to provide an overview of the law. Sorry for the typo in the slide right there. And it's going to be a comparative overview. There's no law in the country that's called the Elder Abuse Act, and very few legal provisions even apply just to older people. So what I will talk about are key laws in each jurisdiction, so each province and territory, that are particularly relevant to elder abuse response. And I'm not going to go province by province, although the guide will, because it's just not enough time. So I'm going to give you a comparative and sort of thematic overview of the different kinds of laws. But ultimately, in your own day-to-day work, I just want to remind you that it's really important to look at the laws in your province and territory. There are subtle differences, even when the type of law is similar. I'm going to, in the second half of this presentation, well, I shouldn't say second half. I think the presentation of the law is going to be about 30 minutes, and then the review of the practical guide is going to be 10 minutes. So this second part of the presentation, I'm going to highlight aspects of the guide, and I just want to say the guide is not finished, and that's really intentional because we want to develop the guide by, consulting with stakeholders. I'm going to highlight aspects of the new guide in the webinar, particularly things that are a different approach, because I want to get a sense from you if you think this is helpful in practice before we sort of keep going with the edits. You will receive, I think tomorrow or later today, an excerpt of the new practical guide. So it will be some of the introductory material, and then a sample snapshot of key laws in BC. And then I would love to hear from you about what you think. So Benedict is going to send you a link to a slide when you get the recording of the webinar, so that you can use that survey to give us some feedback. But you can always feel free to email me. My email address will appear in the last slide of this webinar. The final version of the webinar is going to be with English and French versions, but I'm just going to send some English material tomorrow. Benedict and I are hoping to do a French language webinar in the fall. I'm really happy to do my best to answer some questions at the end, so that will be kind of the mini sort of third part of this webinar. And I'd asked Sarah Pond from our office just to keep an eye on the chat box in case there are questions that can be asked along the way and answered quickly, but I'm not going to look at the chat box at all, because then I can't give all my attention to you. So I always need to say, just because I'm a lawyer, this presentation is not legal advice. We're not going to talk about your specific situations and tell you what to do, but if you need to be connected with someone who can help you with legal advice about an elder abuse related problem, send me an email, and I'm happy to try to help connect you with someone. I notice a lot of people who are on the call today are folks who can do that. We have a lot of lawyers on the line, which is fun. So just to say a couple things about the Canadian Centre for Elder Law before I start, if some of you are new to our work, I recognize a lot of names, so I can run through this really quickly. I want to say we're part of a nonprofit. We are independent of government, although we get project funding from government, including the funding for this work on the practical guide. Our work examines legal and policy issues related to aging, and we are striving to improve laws. Often we do that with reports that make recommendations for change, reports developed working in collaboration with stakeholders in the region that matters for the laws we're looking at. And we also develop resources to help everyone understand the law better, the practical guide is an example of that. We've produced specific tools for lawyers, healthcare professionals, seniors, and others. And we're trying, as the years go on, to be creative about that. So we have documentaries. We just launched a series of animated videos. We've done a wall calendar once. Personally, I've been at the Canadian Centre for Elder Law for 13 years. I've mostly settler heritage, and most of my work happens physically on the territory of the Coast Salish peoples. My office, which I can't go to right now, is on Musqueam land, and my home is on the traditional territory of Squamish people. And I would say I learned to be a lawyer helping Indigenous women with their legal issues for the first few years of my legal work. And personally, I really hope to develop the second version of the guide that will be a better resource for people who are assisting older adults who are Indigenous and have experienced abuse and neglect. We use the word Canada in the guide, Canadian in our title, but I just want to acknowledge that I have a bit of discomfort about using the word Canada since we are a nation born out of colonialism, but just bookmark that issue for another conversation. Before I joined the CCEL, I actually worked as a victim assistance worker, so I bring a little bit of that perspective to my work. So just a warning here, I'm not covering all of the law of Canada today. This review is fairly high level, and I'm not going to go into too much detail about every jurisdiction and move conceptually. As we review the guide over the next couple months, I'd love to hear from people who are doing frontline work in their community. At the beginning, I want to acknowledge the deep expertise that folks have who are working in Ontario or BC or Alberta. And please keep in touch so we can create a version of the guide that reflects your experience. Some folks have already reached out and contributed, and that's probably my favorite part of doing this work. So this slide summarizes some basics of what I think is important to appreciate about laws that apply to elder abuse and neglect in this country. I'm hearing a lot of beeping, Benedict. Should I be hearing all this? Beeping?
Please hold just a moment. I think we still have someone.
Okay, thanks. Just want to try to get the best sound for everyone.
I know. Just a reminder. Hold on. There is someone on the line who is connecting and not muted. Please, I'm trying to find you, but you're not appearing on my list. But it's creating echo. So please, everyone, mute yourselves. Krista, is your computer sound down?
My computer sound is off and down, but I'll do it again just to make sure it's off and down. Okay. So.
And otherwise, the little beeping are just people coming and going and connecting. So unfortunately, okay. I can't turn that off.
Okay, just wanted to make sure that wasn't a tech issue we should deal with. Okay, so there's no single Canadian sort of elder abuse law. And we say we have different statutes that have been developed to address abuse that occurs in different kinds of circumstances. In some instances, multiple laws will apply, and it depends on the circumstances of the older person involved and who is hurting them. The second thing I want to say here is that provincial and territorial laws do dominate. And that's mostly because legal subjects related to elder abuse and neglect fall within the jurisdiction of the provinces. So this means the federal government doesn't really have authority to make laws, and this really flows from how the Constitution of Canada sets out the division of powers over different subjects. You may have heard many folks recently calling for federal legislation regarding long-term care in response to problems illustrated by the pandemic. So it's a tricky ask because traditionally long-term care is a provincial and territorial responsibility, except of course for facilities run by Veterans Canada, as the military is federal. So that is just your mini lesson in constitutional law for the day. And I just raised the issues because constitutional law is part of why elder abuse and neglect law is territorial and provincial, and so sort of fragmented. Every province and territory has taken a unique response to developing a mix of laws that provide tools to responding for abuse. And I don't put any judgment about what's the best approach here today. I just want to help you understand different approaches. Finally, criminal and civil law do apply, and criminal law is an example of federal legislation that can apply to elder abuse. If a person wants to take legal action regarding elder abuse, there may be criminal options, but it rarely presents options that are the most compelling to abuse survivors. But they are part of the toolbox. So I'd encourage you to think of the law as really like a toolbox, different options to choose from. So I'm mostly talking about provincial legislation today, but I will briefly talk about criminal provisions. I'm going to run through them really quickly, and I'm mostly putting the slides in the PowerPoint so you can look at them in your own time. So I'm going to talk about legal terminology just for a few moments, because we do have people who aren't lawyers on the line, and I think sometimes this language can kind of make it harder for them to follow the conversation. So I've got 3 points here on this slide, and bear with me, lawyers on this line. I know you know this stuff already. Sometimes I use the word legislation, and legislation refers to written laws created by government. So you might hear about statutes, acts, and codes. Laws passed by provincial or federal parliament are called statutes, and they go through multiple readings before they are approved. They can also be changed by more laws or interpreted by judges. And the title, the statute, will usually have the word act or code in it. So, for example, Adult Guardianship Act, Criminal Code of Canada. So I will say statute a lot in my talk. We also have regulations. We call them regs sometimes. They have the effect of law and must be followed. And what they usually do is they provide more detail in the statute. The authority to make the regulation comes from the law, and it would be called an enabling statute. They can be created and changed kind of more easily via order in council, which is a way simpler and faster process than what you have to go through to create a statute. And so as a result, often the nuts and bolts of a law, like the details that really affect your day-to-day practice, will be in a regulation. So it's really important when you're looking at your work to, once you know the statute, to go and look at the regs. There could be one, there could be many. And if you miss them, you're not getting a full understanding of your obligations or under the law. Of course, laws are also created, common laws. They're created by judges. They have the same effect as Parliament, but I'm talking about statutes today. Each province and territory has taken a unique approach to developing a response. And so there are laws to address abuse of vulnerable adults. Legislation also produces agencies with a mandate to support adults who experience abuse or respond in some way. Elder abuse laws across the country, and this slide identifies a range of different types that I'm going to focus on today. They are adult guardianship and adult protection legislation, family violence legislation, care facility legislation, and public guardian and trustee legislation. I'm going to mention a couple other unique approaches. There are other laws for sure that are relevant to your work that I'm not going to talk about today: healthcare consent law, power of attorney legislation, mental health law, human rights law. We may cover some of those types of laws in the practical guide, and that's one way you can support our review when you look at the BC snapshot, is let us know, is this too much, is this not enough? Do you want to hear more about, for example, mental health law? So adult protection legislation was created to respond to abuse and neglect of vulnerable adults or adults in need of protection, not specifically to support or protect older adults per se. The laws were designed to respond to elder abuse, but also to abuse of people living with disabilities. And each statute uses different language to characterize the adults that it applies to. Generally, these adults who are adults who are not able to protect themselves or access assistance independently, but different words are used, like adult in need of protection, vulnerable adults. Under the law, a person may report abuse to an agency designated in the law, and the agency has an obligation to take action. The laws generally do not create mandatory reporting regimes, but there are some exceptions. So reporting abuse is mandatory in Nova Scotia. The newer legislation created in Newfoundland and Labrador also uses more mandatory language. And Prince Edward Island's legislation generally makes it an option to report, but they call it an opportunity report, but makes it mandatory for folks working in a place or context where they have a duty of care to report abuse. So reporting is handled in a kind of nuanced way in different legislation. But certainly in all the laws, reporting triggers a duty on an agency designated in that legislation to respond, generally by starting some kind of investigation. Adult protection legislation defines abuse and creates powers to respond, and their powers kind of vary. I'll talk about them in a moment. Adult protection legislation exists. Specific sort of statutes for adult protection exist in BC, Nova Scotia, Prince Edward Island, Yukon, and more recently Newfoundland and Labrador. So you can see the statutes on this slide. Most of the slides in this presentation have links directly to the statutes. I'm sorry for this slide, the links fell away, but I can send them later if that's something that's helpful to folks. Nova Scotia has a sort of shorter statute. Yukon has a much more lengthy statute that also deals with substitute decision-making and adult protection kind of together in one piece of legislation. You'll also find some protective elements in guardianship and substitute decision-making legislation in other jurisdictions, but these are the 5 jurisdictions that I would say have a full adult protection regime set out in law. And these statutes provide for some very broad powers of intervention. They're slightly different in each of the 5 statutes. So this slide is focusing on BC's Adult Guardianship Act. The designated agencies in the legislation have the power to conduct investigations, access private information, enter premises and examine the adults with a court order, make a report to police or the PGT, and I think it's actually mandatory to make a report if they are aware that a crime has been committed, get a no contact order with someone that they think is harming or the adults are putting them at risk, develop a support or assistance plan, it's called something differently in other provinces, and impose a support and assistance plan with a court order. And in an emergency, remove the adult without a court order for a short period of time. So fairly significant powers. One of the ways that adult protection legislation varies is in the kinds of abuse and neglect that are covered. This slide shows the definition of abuse for Newfoundland and Labrador. It's very broad. It includes physical, psychological, emotional, financial, and sexual abuse, as well as intimidation and humiliation. I recall BC's definition also includes over-medication, withholding medication, censoring mail, invasion or denial of privacy, or isolation, like denial of access to visitors. This next slide, I want to make sure you're on the right side because I got a note that you are not completely connected with me. So I'm on slide 19. Benedict, are we on slide 19?
Yes.
Okay. So slide 19 has another definition. This is from Nova Scotia, and you'll see that financial abuse is not mentioned. Financial abuse is often tied to other forms of abuse, so I think there still might be a lever to intervene in financial abuse, but you should know it's not specifically stated in Nova Scotia. Most legislation also has the definition of neglect. This is the definition from Prince Edward Island. You can follow that link and find it in your own time. And I want to mention on the following slide that, so for British Columbia, neglect is defined to include self-neglect. And you can imagine how that significantly expands the scope of when the agencies can respond. So that's something to be aware of. What is the definition? Does it include abuse? Does it include abuse and neglect? And does neglect include self-neglect? I'll leave you to look in your own time as the slide that focuses on the meaning of self-neglect, but it's really about where a person is not taking care of themselves and harm is resulting. But certainly responding to self-neglect produces a lot of challenges for responders in thinking about when is it appropriate to respond, because there is under the same legislation a right to live at risk if a person is able to access support and assistance if they wanted to. So I'm going to switch gears briefly now and talk about family violence legislation, the second type of legislation I want to focus on today. This kind of legislation was designed to deal with spousal or partner violence, but really it's part of that toolbox that we can appeal to in terms of responding to abuse or neglect of abuse of older people, not so much neglect. In many jurisdictions, the meaning of family violence in these laws is broad enough to include abuse of an older person, particularly, and this is an important factor, if the older person cohabitates with the person who's harming them. Family violence legislation defines family violence. Again, the definitions do matter. Defines family member, applies if family violence has occurred, and often if there's a risk of family violence. Because the thrust of these pieces of legislation is generally to get protective orders in place and allows courts to intervene by making an order. There are 9 jurisdictions in Canada that have specific family violence legislation, and the language is fairly consistent. So that's Alberta, Manitoba, Newfoundland and Labrador, Nova Scotia, the 3 territories, Prince Edward Island, and Saskatchewan. And I said the language is pretty consistent, but you'll see, for example, in Newfoundland, they use the term Family Abuse Intervention Act. And when you look at the language, you can see that that legislation was produced with a broad sense of family in mind and with elder abuse in their thoughts. And some legislation has been revised over the years, such as Alberta, to add specific mention of older people. In other jurisdictions than the ones listed on the slide, it's not that that family violence intervention powers don't exist. It's that they're not in a distinct statute and they're embedded in family law. So in BC, you'll find them in the Family Law Act. The Act set out when courts can intervene and the kind of terms that can appear in an order by a judge to address violence or risk of violence. And samples of protection orders terms appear on the slide. Very typically, no contact or communication with a person, the victim, or others, staying away from locations, no possession of firearms or some other objects that are associated with danger, removing the person who's abusive from the scene, police accompaniment to remove belongings if a person is trying to get to a place of greater safety, a requirement to get anger management or some type of counseling. I think some legislation have ability to reimburse the victim for financial losses. But you need to look at the statute in your jurisdiction to get a sense of what are the potential scopes of options and remedies where you live. I'm just including on this slide here a definition of family violence. It's taken from Alberta's legislation. So you see it says intentional or reckless act or omission that causes injury or property damage and that intimidates or harms a family member. So we have damage to the person and to property included. It includes threatened acts. So something hasn't actually happened yet, but that's creating a reasonable fear in the victim. So it includes forced confinement, sexual abuse, stalking, and you see this definition says includes. So it's an inclusive style of definition, not an exhaustive style of definition. And to my mind, that creates flexibility in applying the law and saying what a person is experiencing is a kind of family violence, even though it's not specifically sort of stated in the Act. The third type of legislation I'd like to mention briefly are legislation designed for protecting people living in long-term care. These statutes create a requirement for care facilities to respond to abuse occurring in that facility. And I would say they're grounded in understanding that people living in care facilities are just particularly vulnerable to abuse, due to frailty, due to the living environment. Some of them are actually forced to stay in certain parts of units, and they're going to be in a reduced capacity to get help or even speak out. Some are not even able to communicate. Some people are not even awake. In some jurisdictions, there's a specific law that exists regarding protections for persons in care, and you can recognize them by their very consistent naming of the statutes. There's 3 specific statutes in Canada, Alberta, Manitoba, and Nova Scotia that are protection for persons in care acts, but you will see similar provisions embedded in long-term care legislation. So, the Long-Term Care Homes Act of BC, the Community Care and Assisted Living Act of BC, and the Personal Care Homes Regulation of Saskatchewan all have mandatory responding to abuse provisions. Now, maybe just to say what's different about these pieces of legislation is they are creating a mandatory reporting, but I really haven't heard of anybody being a civilian being prosecuted or fined for not reporting. I'd be curious to hear from anybody on the line if they've heard of that happening. Finally, I want to briefly mention public guardianship legislation. There are some statutes that grant public guardian powers to intervene in circumstances of financial abuse or abuse by a power of attorney, trustee, or guardian. And I list some of the examples of the kind of powers that there could be. They might be to freeze assets, to become a guardian without an application to a court. The powers do vary significantly across the country. On this slide, you can see a list of 6 statutes that are specific guardianship type legislation that includes, and they include provisions for the public guardian to respond, but these are not the only statutes that have some mention of emergent powers of a public guardian to intervene. I know, for example, that the public guardianship, the adult protection legislation we talked about early on in this presentation in Newfoundland and Labrador and Nova Scotia include in them some, in their adult protection laws, the ability of the public guardian to respond. So you kind of see these powers showing up in different places. There are some unique approaches related to elder abuse, where there's sort of elder abuse legislation kind of founded in unexpected places. And I want to mention 2 on this slide. In Quebec, the human rights law, it's called in English the Charter of Human Rights and Freedoms. It permits human rights commissions to respond to exploitation of older adults. So that should probably be in little quotes because that's the language they use in their statute, exploitation of older adults. And if you look at the cases, a lot of them deal with financial abuse, but not all of them. In Manitoba, there is a unique statute called the Vulnerable Persons Living with a Mental Disability Act. And it was developed for the community living sector, so to protect adults with a developmental or intellectual disability. It requires mandatory reporting of abuse in circumstances involving a disability. And this legislation could apply to older adults. Certainly, people with intellectual disabilities are living longer lives, and they often experience aging earlier, like, for example, the instance of dementia at an earlier age. So this legislation is a tool sort of in your toolbox if you're working in Manitoba. Just to revisit mandatory responding, I think this slide is not completely accurate, but I'll clarify. So care facility legislation, if you work in a care facility, you must report abuse and neglect to your supervisor, and the facility has a duty to respond, and there will be steps that are in the legislation. Reporting abuse is mandatory in Nova Scotia, and I think in Newfoundland and Labrador, and in Prince Edward Island, if you have this duty of care in terms of your work. But you also want to consider employer institutional policies. They can have an impact on whether you might have a duty to report or respond. Professional codes of ethics could also have an impact. So it's not just the law that tells you whether you have a duty to respond. Now, I'm going to talk about best practices or guiding principles for responding just at the end of this presentation. Reporting is not always the best response. It's often not the best response. It really depends on the circumstances. So I'd encourage you to really be considerate of what is the appropriate response and not assume response. Phoning Ghostbusters or some other organization to find a problem outside of the older adult to solve what's going on in her life is the best solution. It's sometimes right, but it's often not the ideal response if you want to make sustained positive change in the life of an older person who is being harmed or neglected. I'm just going to do a quick time check. Okay, so I'm going to spend just 2 or 3 minutes on these slides talking about the criminal law. I mostly just wanted you to have the slides so that you could look at them in your own time. The criminal law is the only federal law that I'm going to talk about today, and this is a humongous law. And what it does for those who aren't lawyers is it lists crimes, and it also lists sentencing provisions, and it gets amended all the time. Crimes adding or sentencing provisions being added. And there's no crime of elder abuse in the criminal code. And criminal code provisions are generally age neutral, except that there are some provisions that apply specifically to youth or children or minors. But to provide a little bit of context, I'm just going to run through some slides that give examples of kinds of abuse or that could be criminal acts. So physical abuse could be an assault or an aggravated assault, some kind of forced confinement. Sexual abuse could be a sexual assault, an aggravated sexual assault. I just want to mention that the Canadian Network for the Prevention of Elder Abuse, who is our host today, has created some excellent resources on sexual assault against older adults, particularly in long-term care. So you might want to check them out if this is a topic that you're thinking about. So psychological or emotional abuse, I used to really think that could never be a crime, but we have provisions for uttering threats, for intimidation. Those are just two examples. I think abuse that's emotional could sometimes be a crime. Financial abuse, there are many crimes that could apply in instance of financial abuse. And I want to in particular mention theft by a person holding a power of attorney. Abuse using a power of attorney is one of the most commonly reported forms of elder abuse. And it's there is a specific provision. I think sometimes police think it's just like a personal family thing, but there actually is a specific crime here. And there are tools such as the National Initiative for the Care of the Elderly, NICE, has produced an interesting tools to help justice professionals around charging for abuse of a power of attorney. Neglect, we have provisions for Section 251, which is failure to provide necessities of life. I think it's necessaries of life, actually, to a person. And basically that means that if someone is in a position of dependency on someone else and they're not being provided with food, nutrition, housing, there might be ability to charge. Generally, we see this section used only in extreme cases resulting in death. You can read the cases for yourself. They're quite grotesque. We cover some of them in our counterpoint paper. This slide is just briefly to show you some, elder abuse can be a crime. Some elder abuse might not be a crime. We do have a specific sentencing provision that was added in 2012 that creates an aggravating factor. And what sentencing provisions do is they give a range of sentencing that a judge should consider in applying sentence when someone has pled guilty or been convicted. And there are in the criminal code, it will list factors for different crimes that can be aggravating or mitigating factors. And that means they could make a harsher sentence or an easier sentence depending on the details. And so impact related to age was added as an aggravating factor in 2012. That's relevant to sentencing. So I want to shift gears now and talk about the practical guide, the 2020 version, for my last 6 or 7 minutes here. So just briefly to tell you what our process is. We are going to send you, as I mentioned, an excerpt of the revised guide and also a link to a survey over the next couple days. This version will include mostly new introductory content and one jurisdictional profile for BC. I just started with BC because I know it best. And we'd like to get feedback from you on this material. So here is our process. We are going to complete the revised guide. We're surveying stakeholders. We will complete the guide in English over the summer. We're going to be consulting on snapshots. If you are working in your province and you feel you know the law in your jurisdiction really, really well, feel free to email me and say, I'd love to review your snapshot for my jurisdiction. We're going to revise the guide after we get all this feedback. We will be translating to French and then looking at design. The goal is to do a bit of a wiki book or kind of modular online approach, so it's just easier for us to update this guide in time. and not have to wait many years to provide a revised version. So hopefully technology will be our friend in taking that approach to this work. So a new section of the guide is a lenses section. I've listed the lenses that we are including in the work right now. So trauma-informed practice, cultural competency, humility and safety, dementia-friendly, a gender analytical lens. Sorry, my child is whistling. Hey, sweetie, it's not a good time to whistle now. And sexual orientation and gender identity lens. Insert your survey. We would love your comments on what you think of these sections, and let us know if there's a section that's conspicuously absent and you think should be added. The jurisdictional snapshots will cover the stuff I talked about earlier. So adult protection, family law, legislation applying to long-term care, the role of the PGT, or however they are named in your jurisdiction, but also some other sections such as personal planning and substitute decision-making and supported decision-making legislation, which was not in the 2011 version, but that was, I would say, the most consistent constructive criticism we received about the guide is that that should have been included. We will also comment on human rights and privacy law, and possibly we're thinking of talking about criminal processes in each jurisdiction where there are policies relevant to charging for abuse and neglect. I'm really interested to hear if that's helpful to you in your work. So the guide, the original version of the guide had 10 guiding principles, and over the years I amended that to make it 11 guiding principles, and now it's 12. So it's growing, and I don't want it to get too big, but I'd be really interested in hearing if you think that we have landed on the right guiding principles. In the interest of time, I'm just going to run through the titles. They appear on the next slide. So the first one is Speak with the Older Adults. And this one is first because we want to encourage this to be the starting place, that your work should be guided by what the adults want and listening, not talking at them necessarily, but speaking and listening. So maybe it should be speaking and listening, actually. Respect personal values. Respect and support decision-making autonomy. The previous version said respect decision-making autonomy, and we have added support to encourage people to think about to think about how you can conduct your practice to enhance or support autonomy. Sometimes, particularly people who have experienced trauma or under a lot of stress, they present with not having capacity to make their own decisions, but that can be sometimes a function of trauma and not getting access to medical treatment. So there may be things you can do in your own work to support them such that they will have autonomy to make their own decisions. And this is kind of quite fundamental because so much of our work flows from, and what steps we take flows from whether the older person is able to kind of lead the response and make their own decisions. We emphasize seeking consent and support. Permission, this should almost always be a fundamental, like there could be extreme situations where, they can't provide permission, but if they can, they should be providing permission. We want you to respect confidentiality and privacy rights. This requires not just understanding the law, but understanding policy within your organization. And if there are policies that mean that you have to take steps once the adult has confided in you, please let them know before, as soon as possible, so they understand who they're sharing information with when they confide to you that someone's hurting them. Avoid ageism and ableist thinking. I think we said avoid ageism before, and we've expanded to ableism. Recognize the value of independence and autonomy. And partly why this is here is because a lot of interventions to respond to abuse of adults who are in need of protection focus on institutional living and removing people from their homes, and that can be quite damaging to mortality and well-being, even if it does protect the adults in some sense. So encourage you to really think about what is the right response if removing the adult is being considered. Develop trauma-informed practice to support your work. This is a new principle. Apply a holistic lens. We're encouraging to think not just about the abuse and neglect, but the other needs that the older person has, say for housing, for nutrition, for healthcare, and also to be mindful of the different kinds of challenges they experience in life that are associated with identity, like disability. Are they an Indigenous person? Are they an immigrant? Respect cultural values that can be both tied to abuse and also a source of tremendous resilience and healing. This is a new principle, respect relationships that matter. So, they could be caregiving relationships. They could be, sometimes the person harming the adult is actually someone they care about and care for. And so they need to know that that person is cared for in order to access support for themselves. And also consider unique Indigenous experiences in your response. We want to have an anti-colonial, anti-racist practice, ideally. Just in closing, I want to mention, because we're thinking about the law, that the law is just like a part of the picture, right? There are so many other service providers that provide support. And if you are responding to abuse and neglect in your legal or other practice, you want to know who else is available in your community to provide complementary services. Rarely is one-stop shopping possible, but one-stop shopping is ideal. So if you can refer the older person to an agency that has integrated services that will help with many of their issues, you're going to make it that much harder and much easier to affect positive change, because it's exhausting to get help and to have to go to so many places for help. So I'm just going to take us to the last slide and say thank you. I know that Benedict has added a slide with some other options for subscribing to our newsletter. They will be in the links that you're left with. And just say that, this is our website on this final slide. All of our tools we put up on there are free. The 2011 version of the Practical Guide is there. Hopefully we'll have a new one, that's a new and improved one for you by the end of the year. You can feel free to email me and follow the CCEL or me on Twitter. I do try to post lots of relevant material to elder abuse and neglect. And Benedict is our webmaster for the elder law site now. And as you know, she knows so much about this area as I work with CNPA. So there's lots of elder abuse and neglect content on our Twitter feed. So I'll just pass it back to Benedict for questions.
Great. Thank you so much, Krista. That was amazing. I'm just going to grab the controls back really quickly, and that way I'll be able to share my screen, and we're going to get to the questions. So we have a few already. Sarah has been doing a great job trying to answering a few as we went along, but I'll start with, let me get back to it. Kevin is asking, is there a plan to include an easy to navigate decision-making algorithm or decision tree for how to act when you're suspecting elder abuse?
In the Practical Guide?
Yes, I assume.
Yeah, that's an interesting question. I've been thinking about that a lot. And one of the challenges is that we can't produce really a national one. But I think probably what we would do first, we are linking to decision trees that already exist in each jurisdiction. But thank you for that question. Sarah and I are going to think about, is there a way to distill each snapshot down to a bit of an algorithm? So I know for the left-brained folks in the world, it's useful to have things distilled into kind of binaries. So thank you. We'll definitely think about that.
Great. Next question from Don. He wants to know how uniform or varied is the role and actions of the public guardian and trustee across Canadian jurisdictions?
As varied as you could possibly imagine, I would say. Like, it's just very, very different. And partly, too, because the ability to respond in some jurisdictions is tied to adult protection law, which varies. We have only 5 adult protection statutes in the country. And each of these organizations is differently named. And sometimes the role of the guardian, the trustee, is split in some jurisdictions. And it doesn't have the same status in each jurisdiction. So enormously variable. You really do need to know what the practice is in your jurisdiction, and we will try to be extremely clear about that in the Practical Guide.
Great. Question from Kim. Does the adult have to consent to assistance?
In regimes that have adult protection, yes and no. So if the adult is able to, I have to probably break it up in a sense. In general, if an adult is able to protect themselves and make their own decisions, there can be no forcing of interventions because the adult protection legislation will not even apply. So they have to both be experiencing abuse and neglect and in need of protection. And their ability to consent is very tied to whether they can protect themselves. So that's the first piece. The second piece is that depending on the assessment of the person's abilities, they do have the ability to accept services, and then it depends on the kind of assistance. So, for example, in a couple of the jurisdictions, if the adult protection legislation applies, the agency in the legislation who who has a duty to a mandate to respond actually becomes their healthcare decision maker. That's different from BC, where they would still make their own decisions, or their guardian or representative or other healthcare decision maker would make their healthcare decisions. But personal decisions are differently. There are different kinds of supports and assistance that can be imposed, and they are subject to different rules. So whether they're financial or healthcare or personal assistance, they're going to be subjected to different rules about whether the adult can and should consent and who would consent if they didn't. But if you're in a situation where a person is able to consent and has mental capacity, meaning there has been an incapability assessment and it's found that they can make their own decisions that are relevant to the support and assistance plan, then they get to make their own decisions. But if they cannot make decisions due to disability, for example, then the court does have the power to impose a support and assistance plan on them. So I guess the broadest answer to this question is it really depends. And then it depends what jurisdiction you're in, and it depends what kind of decision, and it depends whether the adult has the capacity to make that kind of decision.
Great.
This is a problem of national. This is a problem of national. There is no simple answer.
Okay, so we have a couple more questions, and I think we still have about 7 minutes, so that's great. Don wants to know, for professionals who are aware of a duty, sorry, I lost the question. Where did it go? Professionals who are aware of a duty to report, it is often unclear to whom or to what agency one must report. I hope your guide will provide some clarification on that point.
Yeah, absolutely. So, I think often the legislation says that the report is to the minister, but in practice, it is a specific public agency representing the minister to which you make the phone number. So absolutely, that's something that we will make very clear. And that's another reason why we want to consult with stakeholders, is to make sure that what we say is very consistent with practice, and to check and see that the agency that you're supposed to report to is actually an agency that accepts reports.
So I guess connected to this question, we had a question from Vanessa who asked, are there any jurisdictions that specify duty to report to police, or is it always reporting to other authorities?
Yeah, so in BC, there is the health authorities who are the designated responder for abuse. If they determine that a crime has occurred, then they must report to the police. So it's kind of a double layer. There's not a public duty to report to the police, but the designated agency must report to the police. I haven't seen that in the other adult protection regimes, but that's something that I'm going to be checking shortly, in general, adult protection regimes do not provide you to report to the police at all. So it's to a designated responder.
And actually, also connected to reporting, a question from Michelle. The duty to report is super clear for adults living in facilities, but it does not seem as clear when the person is living in their own home and receiving home care. Is this
Yeah,
something
that's
that
interesting.
is addressed?
Well, it's a good question because, so as I mentioned earlier in this presentation, we have some jurisdictions that have protections for persons in care legislation, and they do set out very clearly that if someone is living in a kind of communal housing setting covered by that legislation, there is a duty to report, and then certain things will flow from that. So the 5 jurisdictions that have adult protection legislation, they will say if there is they will either say you can report or you shall report or you must report. And my reading is that an adult in BC, you may report. In Nova Scotia, you must report. In Prince Edward Island, you may report unless you work in certain kinds of positions where you have a duty of care. That's probably like healthcare, policing. Then you must report. But the language obfuscates a bit. I agree. Like legislation is not always drafted in a really clear way. And I hope the goal is for our guide to sort of bridge that difference and make it clearer.
And Allison is actually asking if you will be including privacy legislation in the guide.
Yes. Yeah. So in 2 ways. One, in terms of what is the privacy in a person's health and personal information if someone is responding to abuse, and in terms of adult protection, to some extent, 0, right? Like if there's investigations, they can access your stuff. But certain professionals still do have privacy obligations. And then there's the other side of the privacy is that there's some privacy and protection in terms of informants. So if somebody reports abuse, they do have some protection in terms of their anonymity. So yeah, we will be talking about privacy in terms of adult protection regimes and also privacy in terms of professional obligations.
Great. We have a few more minutes. I have a question from Charlene. She's asking, does consent have to be in writing or can it be implied consent?
That's a good question. So, I would say the 2 options, they're not in writing or implied consent. There's stuff in between, right? So commonly consent is verbal. We say yes or no. And consent to services versus consent to healthcare versus consent to handing over power. So it depends what it's consent to. In certain kinds of agreements where you're handing over authority, such as powers of attorney, for example, the consent is in writing. It's part of that document. When you get health care or agree to health assistance associated with an adult protection intervention, it's usually a conversation, but certain physicians or hospitals may want you to give written consent for procedures. Very common with surgery for things to be in writing. But in most contexts, consent is neither implied nor in writing. It's verbal. And I would encourage you to be very reluctant about implied consent. That even if someone, and whether they're applying whether it's about consent to an intervention or consent to talking to you about their situation, consent to calling the police, consent to a support and assistance plan, unless they aren't able to communicate, you should be having a conversation with them. If consent is implied, there probably wasn't a robust conversation that gave them an opportunity to say yes or no, or write down yes or no, unless there is like a communication issue that means they cannot speak or write. Sometimes I would say implied consent is another way of saying I didn't really check carefully, but I think that they agreed. So I would encourage you to be really critical about the notion of implied consent. But yes, implied consent is sometimes appropriate.
And we're technically reaching 11, but I have just one more question on the list for you from Anita. Are you going to look into various cultural groups and immigrant population, for example?
Interesting question. So, does this person? Maybe I'll answer it depending on different questions. So, if the question is, are we considering the experience of people in different cultural contexts? Yes. And are we talking about abuse? Are we talking about different cultural factors or facts? For sure. And a number of the lenses that are part of this new version of the guide do talk about culture and community a lot. Are we consulting with people from different cultures and making sure the guide is the best guide possible? That's a good point. And so I'm going to make a note to make sure that we do that. And including talking to folks who work with immigrant and culturally diverse practices in their populations in their own work. But it's not a research paper on elder abuse that looks at the diverse cultural experience of elder abuse. That would be a whole other paper in and of itself. So if someone wants to type in clarity on that question and let me know if I haven't captured the question, please go ahead.
Yes, and this is just a good time to remind everyone that right now I'm sharing on my screen our contact information, including yours, Krista, your email address. So if there are any follow-up questions or anything additional you wanted to clarify with Krista, you can get a hold of her then. This brings us to the end of this webinar, so right on the dot almost. Oh, it's sorry. I realize you might not have been able to see the contact information. There it is now. We'll be uploading the slides and the recording between this afternoon and tomorrow morning. Thank you all for attending. Thank you, Krista, for this very thorough presentation, and Sarah for providing backup on the chat box. And we'll be in touch with you very soon for our next webinar.
And thanks for these really, really great questions. They're very, very helpful in developing the guide.
All right. Thank you, everyone. Have a great day. Bye, Krista.
Bye, everyone. Thank you so much. The